Tall, are you ready?
Yes, I'm ready. Today is the 19th of February, 2026. In the matter between the state versus Anoj Singh, accused number 1, Brian Molefe, accused number 2, Siabonga Dama, accused number 3, Tamsanga Giani, accused number 4, and Malusi Gigaba, accused number 5. The matter is before the Honorable Acting Deputy Judge President Mudau, as it pleases the court.
If the state is ready, you may proceed.
May it please the court, my lord. I am Advocate S. Manilal. I appear on behalf of the state in this matter. I appear together with my colleagues, Advocate Creel and Advocate Deploy.
The details of counsel from the side of the state were given to my register. I don't seem to see them here. Were they entered? Their details.
Lord, I'll provide that to you.
I need to know who's who.
Thank you, my lord. I'll do so. Lord, all 5 accused are before court this morning. Accused number 1, 5, has been released on warning. The accused are represented as follows, my lord. For accused number 1 is Advocate Panda Gigaba. For accused number 2 is Advocate Mutau SC.
Perhaps can I make this following practical suggestion? Counsel for the accused would introduce themselves and face themselves. I think that will save you somewhat.
As it could be.
Confusion. I could see the excitement from the side of Mr. Pope.
Being called Mr. Mudau.
Okay. So here we are appearing for the state and Mr. appearing for...
May it please the court, my lord. Advocate Annelene van den Heever, for accused number 1, I'm instructed by Mr. Tepu Matopo of Matopo Attorneys. May it please the court.
As it pleases the court, my lord, it's Mpofu. Appear for accused number 2, Mr. Brian Molefe, instructed by Mulaba Attorneys, and Mr. Mpo Molefe of Mulaba Attorneys. May it please the court.
May it please my lord, I appear on behalf of the 3rd accused, Mr. Gama, instructed by Galactio Inc. Ms. Simpson is in attendance with me today. I need to apologize to your lordship. I was sitting in 4C, and eventually when I noticed that there was nobody else arriving, I went and tried to find out where we were, and my attorney and I were on our way up to introduce ourselves to your lordship when we got a call to say the entire party is on their way down. So I apologize for not having been there. I wasn't late. In fact, I was here at 9:30 this morning.
I'm relieved to hear that. I'm very content knowing you, Mr. Audrey.
I'm never late, my lord.
Thank you.
Thank you.
This court pleases, my lord. I'm for accused number 4, Mr. Gianni. It's J. Fenter. This court pleases.
Instructed by Ulrich Rule, is that right?
I am from Ulrich Rune Associates.
Oh, I beg your pardon.
My lord.
Yes.
Please, my lord, I appear for the 5th accused, Mr. Gigaba, instructed by Ian Leviton Associates, R.A. Solomon SC.
Thank you, Mr. Solomon. Here we are. Can we do get through the preliminaries as it were? Would any one of the accused require an interpreter or not?
Not from our side, my lord.
None, my lord.
We don't require my client.
None, my lord.
Thank you. None.
Thank you, my lord. Lord, on the 30th of January 2026, at the Palm Ridge Regional Court, indictments were served on the accused and the matter was transferred by way of a notice in terms of section 144.
Just one moment. Mr. Paul. Your holding matter.
Yes.
Lord, this matter was transferred by way of a notice in terms of section 144, subsection 4, A Roman numeral 2 of the Criminal Procedure Act, for the accused to make their first appearance in the High Court. Lord, today is that appearance. Lord, there are certain processes to be followed before a trial date can be determined in this matter. Therefore, my Lord, I will deal with the following aspects that needs to be resolved. The first issue that needs to be resolved is the issue of the disclosure of evidence.
That is yet to be done.
Lord, disclosure has been done in the regional court. However, just by way of background, accused number 1, 2, 3, and 4 were arrested first. And they appeared in the regional court on the 30th of June last year. They were thereafter requested to provide the state with hard drives so that we could disclose the evidence to them. That was provided to the state, and we made disclosure to accused number 1, 2, 3, and 4. Accused number 5 was subsequently added to the charge sheet, and therefore additional disclosure had to be made. The state then requested my learned friends to return the hard drives so that we could also copy the additional evidence on the hard drives that they had supplied previously. Lord, that has been done, and this morning we have provided to the defense legal representatives the hard drives where the additional information has been disclosed. Lord, accused number 5 in this matter, despite being reminded on 2 occasions to supply a 5 terabyte hard drive so that we could disclose the evidence to him, to date hereof has not supplied that hard drive. So in essence, regarding disclosure, accused number 1, 2, 3, and 4, the evidence has been disclosed to them. In respect of accused number 5, we have not received a 5 terabyte hard drive from his legal representatives for us to disclose the evidence to him. Lord, there's the other issue.
You know, before you get to the other issue, I'm keen to hear from Mr. Solomon on behalf of accused number 5. Why is it so?
Thank you, my Lord. My Lord, it has been disclosed to the state that Mr. Gigaba applied for legal assistance from the former department of which he was the minister. And that process has been ongoing. The cost of that, the hard drives to handle 5 terabytes is about 50,000 rand. So it comes at quite a considerable cost. We've only just heard yesterday that that request has been refused on the advice of the state attorney. So we are still considering our position, and now that we know that that avenue has been closed off, whether that decision must be taken on review. But that has been the reason for the delay, a question of arranging the resources to pay for the hard drives. But that's something now that we'll need to discuss with our client and see the way forward. I mean, there's that, and there's some other issues which the state will place on record, which also may concern this firm's legal and my instructions to act on his behalf, because it appears that the firm could be conflicted. One of the state witnesses the firm acts for, I've just been told. So that's something else that needs to be resolved.
That's a separate issue. I was just keen to hear about this.
Yeah.
Okay. There you
Thank
are,
you.
David. Any further concern regarding that?
Yes, my Lord. My Lord, with respect, perhaps my learned friend and accused number 5 needs to shop where the other counsel have shopped regarding the purchase of the 5 terabytes. The costs that they've indicated, 50,000 for a 5 terabyte hard drive, cannot be 50,000 rands. We have estimations of that, and for a 5 terabyte hard drive would cost approximately 3,000 rands.
I see, Ms. Van der Heek.
Indeed, my Lord, it is, sorry, my Lord, it is about 3,000, depending on the quality, of course, of the hard drive, can be a bit more or a bit less.
Mr. Mbofu seems to agree.
I do, my lord. According to my information, it's in the vicinity of about 5 at worst.
I don't dabble in those things, so I have no idea. I have no idea.
Okay, so yes, at the
Yes, my lord. I'm actually sitting with my box here, and the price on the box is 3,599 rand.
See, there you have it. You save yourself a lot of money. For what that should be.
I'm very grateful to the court and to my colleagues.
Yes. Do you want to take instructions from Mr. Gigaba as to how soon?
I don't think we need to on that at that level of cost. I'm sure.
I don't know. I want to play safe on my side, well, so that this must not be an issue tomorrow.
Yes.
Yes. Otherwise, we'll be
Do
meandering.
you want me
along.
to do it while we in
By all
session?
means, right away. Otherwise, you waste time in duty. We put it to rest.
Thank you, my lord. I have taken instructions. It's not a question of 1 5 terabyte hard drive. What the state asked us for, and this was in an email, is to supply 2 times 5 terabyte byte hard drives and 5 times 10 terabyte hard drives. So it's not as I put it, and that comes at I was told at a cost of about 50,000.
There you have it.
No, just to provide clarity regarding the hard drive sort. My lord, there are 2 data sets here. One is the docket, and on the docket we could copy the entire docket on the 5 terabytes. The 55 terabytes, my lord, relates to a different data set. That relates to the Transnet server, the regiment server, and the Trillion server. My lord, 3 of my learned friends are involved in another matter relating to Transnet. And on that particular matter, the state made available to them this 55 terabytes of hard drives, and that was for the server, the Transnet regiments and Trillion server. The state did indicate to them that the state does not intend leading evidence on the server. The servers were merely provided so that should the defense wish to dispute any document that a witness will testify on, the witnesses have attached, for example, emails to their statements. And if the defense wishes to dispute the email, then they have been provided with this 55 terabytes so that they can authenticate whatever emails or other documents the state is using. So whatever the state is using by way of documentation has already been disclosed, and that's in the docket. However, for authentication purposes, if something is disputed, then they could go to the 55 terabytes to retrieve and to authenticate such documentation. So the same information was provided to my learned friend for accused number 5. If he requires that, we will be able to provide it, and in that event, they should supply us with 55 terabytes of hard drive so that we could copy it. So it's a decision entirely up to them, whether they require it or not.
Mr. Son, I'm sure you.
Yes. Well, we only know what they asked us to supply them with, and as I say, it was 2 times 5 terabytes hard drives and 5 times 10 terabyte hard drives. So that's what they've asked us for, and that's what we've been inter alia wanting to get legal funding for. But now that that avenue is closed, we have to just review the position. Of course, we need this information. It doesn't help only to supply one 5 terabyte hard drive. If they are going to refer to other documents, they may not be necessary to be perused, but they need to be available to us. So I imagine we're going to need 55 terabytes hard drives that can accommodate them in 11 different hard drives, it seems, of 5 terabytes each. So that's what one's talking about.
What about the contents of the docket at this point?
I beg my Lord's
What
pardon?
about the contents of the docket that you refer to?
Well, I mean, that's, I understood as part of what we need disclosure of. But we don't want to hold up matters. I mean, we will, it's obviously information we need. We will undertake to give them the hard drives. They must just give us a reasonable period in which to do so.
And what is the reasonable problem?
I would say 3 weeks.
My Lord, these are issues that causes delay in this particular matter. And we're trying to avoid that. And therefore we had made contact with the legal representative for accused number 5 timeously and sent 2 reminders regarding this hard drive.
That might well be so, but can we fast forward to the here and the now? They are asking for 3 weeks. Does that have an impact on the date of trial that we might arrive at?
My Lord,
between now and the 3 weeks.
My Lord, I have a proposal that I wish to submit regarding when the matter should be postponed and for what purpose it should be postponed. So, just to deal with that, we have made disclosure already to accused number 1, 2, 3, and 4. There's an issue with accused number 5, then providing us with hard drives. My proposal is that we postpone this matter for, well, as an informal date, for the defense to come to our offices and to do a comparative exercise with what has been supplied to them versus what we have in our possession. So compare their hard drive with the hard drive that we have with the electronic evidence. In that way we will, it will alleviate any issue regarding a document that they may claim they cannot open or is not part of the disclosure. So to do an audit process between ourselves, and for that I suggest a month. So in that month it would give accused number 5 the opportunity to get his hard drives and to supply it to us so that we could copy that for him. And if possible, within that month, for him to also come and do that comparative exercise. So for now, without having to go through what data is on those hard drives, is to do a comparative exercise so that there's no issue regarding documents that have not been supplied and what has been copied, etc. Let's alleviate that so we move onwards from there to the next process that should unfold. So what I'm suggesting is informally we agree that this matter should be, that the defense come to us by no later than the 30th of March to do this exercise. But my proposition is that this matter be then postponed for a period of 2 months to give the defense an opportunity for whatever issues that may have arisen. For example, my learned friend for accused number 5 to resolve this issue of funding, etc. After 2 months, we appear back in this court. Those issues can be resolved, and then we can set the next processes. I would imagine that the defense would require request for further particulars, etc. We can set a clear timeline regarding request for further particulars, replies, etc. Once that process is finalized, then we can talk about setting a pre-trial conference and thereafter trial dates, etc.
Any further submissions, Councillor?
The last submission, my Lord, as my learned friend alluded to for accused number 5, is that there is a potential conflict of interest with the instructing attorney for accused number 5. Lord, we have a potential witness which we have been pursuing over the last year. That witness is represented by various counsel. Some of them are overseas based. My learned friends for accused number 1, 2, 3 are well aware of this fact, because the same witness is required on the other matter that they are appearing for representing the accused for. Lord, we have reached a point late last year where it was agreed that a affidavit, or at least a draft affidavit by this witness, be provided. That affidavit was not finalized, and hence we were not able to even disclose that affidavit to the defense on the other matter. Lord, thereafter, we have learned that the instructing attorney for accused number 5 is representing that witness, and is representing the accused number 5 in this matter, which poses a clear conflict of interest. Lord, as during November last year, we wrote and indicated to them that this would be a conflict of interest, and we wanted a resolution, or we wanted an answer. He can act for either one or the other. Either he's acting for the accused in this matter, accused number 5, or he's acting for the witness. He can't act for both, because that is a potential state witness. We have not got a reply regarding that, and we would want that issue to be determined, because we cannot have a representative who's conflicted in this matter representing accused number 5. So that's the last submission that I wish to make, unless the court wants to hear me regarding dates.
It would seem to me, from what I'm hearing, we are a long way off from a determination of the trial period or dates, for the reasons that you alluded to. Were there any attempts made to engage your opponent's counsel on behalf of the accused to come to some kind of agreement as to what must happen when?
No.
Or your own doing it now in open court?
My Lord, I have not had the opportunity to discuss with all of the representatives. At least one of them was not here at the time. However, I did discuss this matter with Advocate Mpofu, SC, regarding the way forward. And the proposal is to postpone this matter, the next holding date, for 2 months, for a period of 2 months.
I've heard that part.
And the dates that we suggest is the 24 April 2026.
All right. Can I then hear from counsel on behalf of all the accused whether there are any issues in relation to the proposed date for the reasons alluded to by the state?
My Lord, from our side, the 2 months, I think, is a decent proposal, because now, having had experience with this kind of matter, issues of getting proper instructions via the insurance companies is going to take time. So I think 2 months to start off is a good time period. May it please the court.
Yes, court, please. My Lord, I also agree that the ballpark of 2 months is reasonable. I only have a concern with the specific date proposed.
Me too.
And my learned friend also.
I see you are committed somewhere?
Yes, I have a trial starting on the 23rd, but I'm sure if it's a week later and so on, we can discuss with our learned. But the ballpark of about 2 months is
Let me first hear from the rest.
my Lord, I must just say this maybe. The reason why we say that period is reasonable is because, just to give perspective to the court, I'm not a techno savvy person, but I was told that 5 terabytes means millions and millions of pages if you translate it into hard copy, something that can fill up this room. So the period of time that might be needed for us to even be in a state to have the meeting might be a little bit optimistic. particularly if accused number 5 is only going to receive the documents within a month. But I'm sure all of us will try. But I just thought I should put it to the court that this is not an ordinary, 2 files. We're talking about quite a lot of documents.
For comment, can I hear Mr. Aldrich?
As court, please.
My Lord, for housekeeping purposes, I agree with the postponement. The date is, of course, something that remains problematic, even when I have regard to my diary. So I think the only thing that remains outstanding is to make a determination as to that date.
Mr. Fenter?
Thank you, my lord. On the way forward, I've got no objection on the suggestions.
Mr. Solomon?
I echo what Mr. Aldrich says.
I see. So can we then come up with a date that then will be suitable to your opponent? What are you proposing?
My Lord, yes, I've just been whispering to my learned friends. We're thinking about the first week of May, around the 8th, if it makes no difference. We just checked our diaries now.
Lord, a week's difference is not going to have an impact, so I have no objections to the matter being set down in the first week of May. May I propose a definitive date, my Lord?
The 8th.
The 8th. Just be proposed. 8th May, 2026.
Does it suit the state as well?
It does suit the state, my Lord.
Everyone else is happy?
We confirm the date, my lord.
Let's go, please.
Is there anything else that requires my determination?
Not from the state side, my Lord.
All right, I'm going to invite the accused to stand up now. This matter is being adjourned to the 8th of May this year, back before this High Court, for reasons already placed on record. To summarize, that is a change of documents and information that the state has in its possession in the final prosecution of this matter. Bail is extended to accused number 1 through to 4. Mr. Gigaba, I'm told that you are out in warning, so you are warned to be here no later than 9:30 on the 8th of May 2026. I hope I'm clear, gentlemen. Let's not nod our heads. We are on record. Can I get from Mr. Singh? Mr. Singh, yes? Do you understand?
Yes.
Mr. Mulife,
Excuse me, sir.
do you also understand?
Yes, I do, sir.
I'm glad to hear.
I thought that's why I had legal representatives.
I beg your pardon?
No, nothing, sir.
Mr. Gama?
Yes, it pleases the court.
Thank you. Mr. Kiani?
Understand?
Mr. Gigaba?
Yes, my lord.
Thank you. Without any further ado, this matter is so adjourned. This court is
Let's go.
As God pleases, my lord.
Lawyers, you do.